100% shows that the work was being executed. Now, question is still, I mean, you may still have a point that, there were delays or deficiencies on the part of the respondent. Where did you raise the issue of delays or deficiencies?
No, no, we have said so in the written statement, coupled with the fact, there is a finding of fact that the work completed was only to the extent of 90%. And therefore, my lord, the learned trial court held this, my lord. Please have a look at page 175.
So what evidence did you produce to establish that there were delays?
Yes, 30th of next year, P11, your lordships may see. Or my lord, lordships may please have an next year P12. Now this letter, which we have pointed out, my lord, on 30th November 2012, the judgment in question says that
you will tell us what is the evidence which was there.
Lord, this was one of the letters, my lord, 30th November, and the rejection letters at document P11. Kindly just see, my lord, annexure P11 from pages 102.
You had to prove your defense that there were delays and that there were delays or deficiencies by producing the evidence of a person cognizant of the contract which was being performed, and then establish, by producing documentary material that, well, there was a shortage of work, or there was measurement carried out which resulted in,
Lord, if I may say so with respect, my lord, the next year P11 pages 102 to 115 were the rejection notes. Then, my lord, the chairman of the company appeared as DW1, and then, my lord, 30th November 2012 letter, which was within the warranty period but not considered by the judgment in question, that has been set aside, my lord, on the premise that the work was completed in July 2011. But the plaintiff himself says that it was in 2012. Para 19, if I may just draw your lordship's kind attention, please have a look, my lord, at para 19, page 187. That is, my lord, the fundamental error, my lord, in the judgment. Besides the point, my lord, that para 19,
ultimately, you are here under 136.
I know, my lord. But, my lord, only two respectful submissions. First and the foremost, my lord, the evidence, etc., my lord, even the bills which were presented. The learned trial court has held that these were not actually the bills which were submitted or ought to have been submitted. They have not been proved. Then, my lord, there is a heavy discrepancy on my pointing out the deficiencies, because the High Court says, my lord,
it's purely a matter of appreciation of evidence and all. Peaceful. Thank you.
Yes. Right.
This has to be tagged. This has to be tagged. Ganpati deal.
This has to be done.
When I mean formalists.
But it's kindly see the tribunal's order for a minute. It's PDS.
You are appearing for?
I am on KBL.
We've got other matters which are pending, so we'll.
Well, kindly see, because ultimately the tribunal, I had gone an appeal. The tribunal has decided this issue only on Ganpati deal, not on merits. And with the liberty given that if review is allowed by the Supreme Court, please come back.
Therefore, we'll tag it.
We'll tag it. Because ultimately, even my lords tag it.
Got other